is. But remember, when I ask you, just let me know if you're both here, and give me your updated time announcement on how long you think you need. I have this Munch and Welch case on a motion to modify temporary orders. And if you, who's here on that?
Aaron Culp for Bill Mensch is here. I think probably 2.5 hours, Your Honor.
I'm here. I represent Miss Welch.
And I have exhibits for y'all. Are y'all all ready to go?
Yes.
Yes.
Okay, thanks. Bigger and bigger. Who's here on bigger?
Morning, Your Honor.
Morning,
Scott
Your Honor.
Nitre and Sam Bassett for Carrie Bigger.
I'm Dawn Archer from Mr. Newman's office. I'm here for Craig Bigger.
I think Mr. Nitrate, I don't have anything from y'all's office. There's no exhibits up. So do y'all have exhibits or no?
Oh, we do, Your Honor. My office mistakenly uploaded them into the respondents folder, and she couldn't.
Okay, so then now I'm very confused. So now I need to go back in the box. I'm gonna probably start with the first case because they got all their exhibits ready. But let me figure out, and I think they're in the right places. But let me look at it because I was just looking and noticed you didn't have any. But now I'm gonna need Alicia Racanelli, my court reporter's help on how to unpack when somebody puts them in the wrong folder and what we need to do now. So this is the bigger case, Alicia.
Okay, yeah, I'll move them. I can move them right now. So there won't be any in the respondents. They'll be in the petitioners. So I can move them now.
And so now who's here for the respondent?
I am, Your Honor.
And so you have no exhibits.
I don't need any exhibits.
You don't need any. We're not supposed to have exhibits for you.
No, Your Honor.
Okay. All right. Well, that's good. We'll move those and then we'll probably start y'all whenever we're done with this first case.
That's right.
And then I have Douglas and Gomez, and I have nothing on that case, like no exhibits from either side.
Good morning, Your Honor. Emily Tesmer here for petitioner Natalie Jones. We're here on a motion to enter. I believe this will only be about 10 minutes. We're only going to enter one of our orders. And I think we just have one substantive red line.
Okay. And so I don't have a copy of that though. Like, how would I get a copy of the order?
I can upload it into Box right now if you would.
Well, I would rather you not do that. I'd rather you send it to me by email.
Okay.
But because I don't think I have it by email either. But who's here on the other side?
I am Hilton Moore.
And for those of you who've been before me many times, my favorite thing to do is to determine a motion to enter off of the ISA that I wasn't at, that all of you were at, that I can't even know what was discussed, that I'm somehow going to intuit what you meant in an ISA. And so, I mean, I don't really know what my role is. I've always wondered. It's not really your fault. It's more that I don't really appreciate how the law boxes me in here. But what you think it's just 10 minutes, Ms. Tesmer? Do you agree, Mr. Moore, that it's just like a 10-minute fight?
Yeah, I don't think we're fighting about anything. I think Ms. Tesmer just wanted it signed this morning as opposed to by submission.
Well, then we can do that.
I'm
not determining something, because I get from time to time, I get people to tell me what happened at mediation that I wasn't at, and I don't know how to do that.
Yeah, our motion to enter has both an order to confirm child support arrears that we're not ready to move forward on today. We kind of have some procedural hiccups, and we're trying to make sure that the order we're drafting for that will comport with the language that the OAG will need for that. But also
the OAG here.
I
saw
here,
an OAG
Judge.
here.
Yes, I'm here, Judge. And I've already looked over the order, the one that we're entering today, and I'm fine with that order. It's just not the arrearages order that we had an issue with that one.
So, then Ms. Jones, Ms. Tesmer, my JEA just sent you the email.
Okay.
That I want you to send it to. I'm assuming it's signed by everybody.
So we had a prior order that was signed off by everybody except for the Office of the Attorney General. I needed to make one change regarding our income withholding order language, because we were going to enter one income withholding order for both the modification order and the order confirming child support arrears. But because we're not moving forward on that subsequent order today. I needed to just make that one change to that. And so I don't have a signed order that everyone signed off on with that new language in it.
Okay. So I'm signing what? I'm signing what do you want the court to sign?
Just our modification order. And so would you like
it's a final modification on everything but child support.
Everything but the confirming the child support arrears, correct?
And then all right. And then, well, I'm going to ask, since everybody's here, this should be pretty simple, I think. I guess if you could all sign it, though, is there anything wrong with getting the signature of Mr. Moore and Ms. Campos on another order? Is that not possible?
I think that
It's
should be
possible.
possible. I think it should be possible. I don't know if we need to recirculate for the parties to sign off on as well, because it was an agreed ISA. So
let me think about that. So the version that you're going to upload is only signed by you.
the version I was going to upload because I had to make that change hasn't been signed by anybody, but I don't think Mr. Moore or Ms. Campos has any issue with signing off on that order. They've both seen it. I haven't heard any objections from them.
It sounds like they don't have any. Mr. Moore and Ms. Campos are saying they have no objection. So what language, since this is a final order, what do you put in it with regard to the arrearage issue?
We didn't have any language regarding the arrearage. We were going to address all of that in an order, a judgment confirming the child support arrearage.
I think that's fine. I mean, I'm just trying to think if you put in an order. That it's final, and this was an issue that was part of the modification. I just don't know. I'm trying to, I understand why you're here. I want to be a helpful problem solver for you. But I just don't want to get us all in a situation where we then have to modify a final order or clarify a final order or something like that. So maybe Mr. Moore or Ms. Campos can weigh in too. I mean, I guess you all are in agreement to doing it this way, like having one order and then having a second order come through and it being a judgment confirming arrearage. I think it would need to come to me just because I don't want it to get caught up in another. It's odd enough to where I could see it raising some questions since we're having this conversation.
Well, and we have a little bit of a procedural, I guess, snafu with this because the parties entered an ISA that addressed both the modification and the arrearage. So we have a motion for enforcement and a petition to modify. So the ISA addressed both of those issues. The parties then obtained an order rendering judgment on this that the OAG, who is absolutely a necessary party, what was not part of, and we did that to so that Mr. Gomez was able to obtain health and dental insurance and switch coverage over for the child before we got a final order in place. And so now, because of that, we recently learned that the OAG is going to require some different language in that order confirming the child support arrears than kind of what the parties had set out in their ISA. So there's a little bit of a snafu with that.
What if we did, I'm so sorry to interrupt, but what if we did a temporary order and just reserved the judgments and for the final order? And then so judge could sign off on the temporary order today on the retroactive modification, and then we could do a final on everything just in case there's any issues that need to be fixed in the temp later on. I'm fine either way, but that's just a suggestion.
Mr. Moore?
Well, my client and I are fine with you just signing what she's sending you now. We don't have any objection to anything in it. If you just want to sign it as she's emailing it to you now, I'll say on the record we don't have a problem with that.
I'll make a note. Okay, let's see. You're fine with what she's sending me now too, Ms. Campos, right?
Yeah,
I don't want to add. Okay. And let me see where I think Ms. Tesner, You
Yes.
need to sign whatever comes next. Whatever comes next, the second part of this order. I'm going to make a note. We're not going to go on the record. I'm going to make a note that Ms. Campos was here, Mr. Moore was here, you were here, and that all of you agreed to the form of the order that you are sending the court today. So you don't need to get any more signatures. Just let me do that. And then, but on the next one, I'm going to need everybody's signature. I don't need the party's signature, but I'm going to need Mr. Moore and Ms. Campos's and your signature on the order confirming arrearage. And then rather than sending it through submission to whatever court number it's filed in, I'm going to need you to say, this follows up with the order from, December 19th. This is the second order that we discussed at docket call. And would the court, this agreed order, would the court sign off on this? That's what I'm going to need. I don't know when that's going to get done. I'm going to be out for a week. But it's the Christmas through New Year's kind of time period. And then we'll get it signed when you get it to us.
Okay, so for the order I'm sending you right now, would you like me to just remove everyone's signature blocks and just send that to you as is, even though it's an agreed order? What would you prefer?
Put agreed order on it.
Okay.
Put some language at the top that said Mr. Moore and Ms. Campos appeared and announced their agreement. Like put that in the order because that's what happened. And I'll sign it.
Okay, I can make that change really quickly and send it to you.
Okay, and you'll send it to 201.submission.
Yes.
All right. And let's hope this works. I'm going to go with the spirit of the season that everybody is in agreement and that no one's going to pull that agreement later because I do think we're maybe skipping a couple of steps, but if we're all in agreement, then we're all going to be fine. Thank you.
And Your Honor, I would also like to submit an income withholding order as well, so that we can start.
You bet. Fill it out.
Okay.
Get it all filled out, except for my part, obviously. And then the court will also sign that.
Okay. Thank you very much.
But do them at the same time. Don't send me this and then send me a withholding order in a week. Like I'd like to see the final order and the withholding order at the same time.
Yes. Okay. All right.
Okay.
Thank you.
Thank you. Y'all are excused.
All right.
So then we'll do this. We're going to go to Munch and Welch. I'm not going to do bigger yet. What I'm going to ask, Mr. Nitre, we might do y'all at like 1:30. Miss, who's here for the other side? Miss Archer, is that right?
Yes,
Yep,
Your Honor.
Miss Archer, 1:30. But, if this case in front of you goes very quickly, we could call you back this morning, but I'm thinking 1:30 is probably the safest time. Okay.
Sure.
Why don't you email Frenchie in an hour or email that submission email in an hour and just see, are we still on for 1:30?
And Your Honor, I have a major hearing here in Harris County at 1:30. Would it be okay if I have another attorney come in and finish this hearing? I just want to make the court
Sure.
aware
I mean,
that
I'm okay with that.
Yeah, a
That's
different
not
human may show up.
Yeah. I'm okay with that as long as it's somebody who can, answer questions and be
Absolutely.
responsive and it's not a backdoor continuance, right? Like we're going to go forward with the hearing at 1:30.
Completely understand. I just wanted the court to be aware it might be a different face from our firm.
Understood.
Okay.
Understood. So Mr. Nitre, Miss Archer, you and your clients, if they're here, y'all are all excused. I'll see you back at 1:30. Though if you contact in an hour, Mr. Nitre, and something weird happens in this case in front of you, maybe we'll go forward sooner than that.
Yes, Your Honor. Understood.
Okay. Thank you.
Thank you, Judge.
And I have an AG in this case too. Is the AG here in this case as well?
There are no child support issues today, Your Honor, so I don't think the AG is necessary.
They were noticed though, because they filed they're a party of record in the case. So I just want to make sure they were noticed.
Oh, I see. Okay. I don't
Were
believe
they?
that.
I guess I'm just asking because they're my first party listed.
Well, it's my understanding that we only need the AG at hearings when there is a child support issue.
Well, me too. That's my understanding as well. I guess I'm okay to go forward. I wish I'd have left the attorney. I wish I'd have figured that out before I let Ms. Campos go, just to make sure, because you're telling me there's no child support issue. Is that actually correct? I mean, there's nothing involved here. No decision will affect child support one way or the other.
No, ma'am. The only issue today, we're asking to change therapists for the children. That's really the only issue before the court.
Okay, that's it. Then I think we're fine. But I do think when they're a party of record, I think you just have to notify them. I mean, I'm not going to stop today, but I do think they have to be notified. You're right. Their response would be, we don't want to be here, but
My understanding of the proposed disposition is they're asking for my client to pay for the cost of the therapy. If they're abandoning that, then there are no child support issues.
We are
Unreimbursed medical. Yeah, go ahead.
I apologize, Mr. Gilbreth.
go ahead. What were you going to say, Mr. Cole?
No, part of that, Mr. Mensch is we need to correct that PDI. Mr. Mensch is offering to pay for the full cost of the therapy for Tau Fan, if that's what the court orders.
All right. You ready, Ms. Racanelli?
I am, except I'm having a difficult time hearing Mr. Culp. I don't know, the volume's really down, but I can't hear him as well.
Oh,
Thank you.
Okay. Not sure why. Is that better?
You're just going to need to talk way up. It is kind of soft. Not for sure why.
Yeah, I'm not sure why either.
Ms. Racanelli is used to me, and I'm a loud talker. So we like volume here in the 201st. And so it makes things a little easier. So if you can just speak up, that would be great.
I will do my best.
That helps. That helps right there. I know you're
that-
awfully close, but that actually helps quite a bit.
Okay. Yeah, maybe I'm having some speaker problems or something. I don't know.
All right. Thank you. Okay. So let's go ahead at this point and go on the record. Let me take attorney announcements and who you represent for the record.
Aaron Culp for Bill Mensch or William Mensch.
I'm Jake Gilbreth. I represent Katie Welch.
And then I will state, because we stated this off the record, but we don't have an assistant attorney general with us this morning, but I was speaking to the parties the lawyers for the parties off the record, and they have represented to me that there is not a child support issue at issue today. And so given what we all know, I think, about the AG's processes and procedures, their position is when there isn't a child support issue at play, they generally don't show up for the hearing, and they waive their appearance. And so we're going to go at least start on that process. If for something comes up and I feel like that's not the case, I might shut it down, because this is an AG matter. It's not even just they are listed as the first party of record on the case. And so I just want to make sure if they're not involved anymore, I'd like to know that too. But it does seem like it's still an open cause number where the AG is involved, at least in the child support issues. So, all right, at this point, why don't we do openings for the issue that is before the court today, which is my understanding there's a therapist issue, but let's proceed with the motions.
Thank you, Your Honor. So this case has been going on for a long time. We had a custody evaluation that was conducted by Dr. Daphne Ainsley. Dr. Ainsley gave us her report back in June, and part of that report part of the recommendations in her report were that the parties engage in family therapy with Dr. Michael Bishop, and that the children engage in individual therapy with Tau Fan, or her designee or someone else recommended by Dr. Ainsley. So when that report came through, Mr. Mensch reached out to Tau Fan and Dr. Bishop to start initiating that process. Then in August, Mr. Mensch reached out to Miss Welch to see if if they could get an agreement on using Tau Fan. Miss Welch basically said, I've already found a therapist. There was a disagreement, so I began reaching out to Miss Welch's attorneys to try to see if we could get an agreement on Tau Fan. We sent repeated requests for agreements. We tried to negotiate back and forth. We're not able to get an agreement. Ultimately, we tried to set a hearing. That hearing had been the hearing that we were trying to set had been reset numerous times for various reasons, bad dockets, health issues, things like that. Nothing that really that I'm trying to blame anybody for the resets necessarily. But Mr. Mensch has been wanting to use Tau Fan for the children's therapy since the time that Dr. Ainsley's report came out. However, the children have been working with a therapist named Teresa Marini, who I believe is here today, and so we're asking to switch therapists. Essentially, that's the long and the short of it. Dr. Ainsley had some very specific reasons for her recommendations regarding therapy for the children, therapy for the family. She wanted to. I'm going to let her articulate her reasoning better than I will, but she was, as I understand it, looking for a therapist who was not going to be shy about litigation, who understands high conflict custody cases, has worked within high conflict custody cases, someone who's known to the courts, someone who is known to the people that we kind of commonly use to help facilitate these, the family therapy structure within our community. And it is our opinion that Ms. Marini just does not meet those standards. And we've had some issues about with Ms. Marini. She's, in my conversations with her and her conversations with my client, she seems to be pretty biased against Dr. Ainsley's report. She does not appear to me, or I believe to Dr. Ainsley, to kind of have the qualifications to do the kind of work that Dr. Ainsley was envisioning. And so essentially, we just think it would be better to have these kids working with Tau Fan. We've already got them set up with Michael Bishop's office for family therapy. It took us a couple months to get that agreement. But we were finally able to do that. And so I think just these are high conflict parents. This is a high conflict case. It always has been. And so really what we're wanting is just to give these kids the best opportunity to succeed and the family the best opportunity to try to resolve these issues. As I mentioned before off the record, Mr. Mensch is willing to pay the full cost of Dr. Fan or Miss Fan. And so really we're just asking the court to order that the children start working with her immediately. That is our relief requested today, Your Honor.
Let me hear from Mr. Gilbert.
Yes, ma'am. So first of all, just to adding some more details that I think are important in making your decision. These folks are set for final trial on February 24th of next year. So a little more than 2 months, we're set for final trial.
Are you set on the are you set on the bench trial or a jury trial?
Bench trial. If Dad, one of the things Dad wants to do is to move with the kids. So if they make a jury demand, that's actually a jury week. So, but we're set that week, but currently set for a bench trial. So the underlying order, there's a 2016 AG order. That's actually the parties agreed. And there's actually only one child at the time. And mom has the right to determine the primary residence, and mom makes all the decisions, including after consultation, but she makes the final decision for psychological and psychiatric decisions. Okay, that's the 2016 order. Then there's a 2019 AG order. That's essentially the same thing, where mom has the right to determine the primary residence. Mom makes all the decisions under 153, 132, including the right to make psychological and psychiatric decisions for the children. That's your active underlying orders, the March 2019 order. These folks, there's a petition to modify filed actually by both sides. They were in front of, I think it was Judge Burgess. This is before I got involved. On December 7th of 2020. 2020 is when they were here on temporary orders. December 2020. So 4 years ago, they were here. And dad at that time was asking for custody, to flip custody on temporary orders. And he was asking to make all the decisions for the kids, all 153, 132 rights, including the decision, make psychological and psychiatric decisions. That was denied by the judge at temporary orders. He did change up the possession schedule, but it was denied that dad's request to be sole managing conservator make the decisions. And this is particularly frustrating about this case. They, and when the court has a chance, if I could share my screen.
Yes, hold on. Yes, I just gave you privileges.
So 4 years ago is when the custody evaluation was agreed to. Okay, that's when it got started. Was 4 years ago in December of 2020. The court order actually says that the custody evaluation is supposed to come out July 1st of 2021. 3.5 years ago is when the custody evaluation was due. We got it. We got the custody evaluation, and there's nothing particularly complex about it. They are high conflict, like a lot of these families are, but there's nothing particularly complex about it. We got the custody evaluation in June of 2024. So 3 years after it was due, the custody evaluation comes out. 3.5 years after it was ordered to take place. So we're set for final trial on February 24th. We have it mediated, by the way. Dr. Ainsley.
Are the children? Do you know? Like, what's the age of the children?
Yes, ma'am. So the oldest child is 9. That's Savannah. Cora is 6. And so when Dr. Ainsley reports came out, the children weren't seeing a counselor, and they weren't in family, the parties weren't in family therapy. And one thing that Dr. Ainsley recommended was that they start counseling. She did say Tal Fan, and that they start family counseling. She did say Dr. Bishop. But the idea being, let's get the kids in counseling, get the kids in family therapy. Again, a little skeptical about the report given how long it took, and I have lots of problems with it. But that was the recommendation that they start counseling. So my client, having the right to make the decision, and informing dad and sent emails in August, said, here's who I'm looking at. She consulted with him, and she found Teresa Marini, Miss Marini, who takes insurance, who's a competent professional. Clearly, I think Mr. Culp said needs somebody that's not going to be shy about litigation. Well, she's here. And the kids have been seeing her since around August of last year. By the way, my understanding is that dad's only contact with a counselor is to call her and say she needs to get the kids ready to move because he's asking to move with the kids. And that's his only contact he's had with the counselor. So on October 30th, we were here on the docket. I made the point to Mr. Culp. I was like, has Dr. Ainsley even talked to Miss Marini to see if there's an issue with Miss Marini? And at the time, the answer was no, she hasn't. And we agreed to start family therapy with Dr. Bishop. And then we reset the request that we change the counselor. And then Mr. Culp's client had some health issues, which is not his fault, but then it got reset for today. I haven't heard anything from anybody. I've done conference calls with Dr. Ainsley on this. Nobody's articulated a reason for me why Miss Marini is not an appropriate counselor for the kid, or why my client, pursuant to her rights, both under the underlying order and under the temporary order, when the court didn't change that right, made an inappropriate decision in having the counselor see the children. The only thing I've heard is what Mr. Culp alluded to in his opening was, well, we feel like she doesn't see the world the same way Mr. Munch does, so that she must be biased, right? She doesn't agree with our side, so she's biased. Is the only sort of complaints that I've heard about Miss Marini's qualifications to see this case. Nobody's told me the kids aren't bonded with this therapist. In fact, I think the opposite is true. Nobody's told me that Dr. Bishop can't work with this therapist. I think, in fact, the opposite is true. I think she has the same qualifications Miss Fan does. And so I don't understand why we would switch the current therapist. So back to sort of Dr. Ainsley, not only do I have a complaint a lot about her report, which we'll be talking about at final trial. I have a complaint about her report taking 3 years past the due date. Other things that I have a complaint about her report, but that's a final trial issue that we'll be talking about that. A question for today too is I've asked for Dr. Ainsley's file, right? Because she's an expert witness. They're going to be calling her to give expert opinions today. And the response I've been given is, well, Dr. Ainsley won't give her file over unless there's a court order, which my understanding is they're now agreeing I get the file. But as I sit here right now, they intend on calling an expert witness without having produced her file under Rule 194. And that sort of plays into my theme, which I alluded to by starting with the trial date, is this is a final trial issue, right? Dad wanted on temporary orders to make all the decisions for the children. That was denied. The underlying order, my client makes the psychological and psychiatric decisions. That may very well change at final trial. I don't think it's going to, but that will be litigated in court. And I think we're set for 3 days on a bench trial. That will be litigated in court. So that's the appropriate time. I don't think there's anything inappropriate with this counselor. She's been seeing the children. The children are bonded with her. She can continue seeing the children. And I think it's inappropriate to come in here 2 months before final trial and again ask essentially that dad make the decision on the counselor when we have a qualified counselor seeing the kids. And then I want to end with this because this one really is the kicker on this one. Dad's request is that he be allowed to move to Illinois with the children. That is, not only is he asking for sole managing conservatorship, it is live pleading, he's asking to move to Illinois, which, by the way, Dr. Ainsley says is not a good idea and doesn't recommend that. But under Dad's theory of the case, we are going to try this case in February 2025. A judge or one of your sister judges or a jury, if they make a jury demand or anybody makes a jury demand, is going to say dad has the right to determine the primary residence in Illinois. And I guess under that theory, we're switching the therapist again, right? Because Tal Fan's in Austin. So under Dad's theory of the case, we'd switch from Miss Marini to Miss Fan, who, by the way, nobody's even told me if Miss Fan's available to take the kids, or if it would work with my client's schedule or anything like that. But under Dad's theory of the case, we'd go from Miss Marini, who's been seeing the kids since August or September, to Miss Fan, whenever she's available, who knows, to Dad wins his case and he moves to Illinois and we have a new therapist for the kids under his approach to the case. It's just none of this makes sense to me. They have a final trial. They need to litigate it. It doesn't make sense to me that our child custody report's 3 years late. It needs to be tried, and then this can be determined at final trial.
All right, thank you. I think, Mr. Culp, that was opening. And so we're going to go forward with your evidence. You may call your first witness.
William Mensch.
Okay, Mr. Mensch, please raise your right hand and be sworn in. In the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, Mr. Culp. You may proceed.
Thank you. And do I have the ability to share screen, Your Honor?
Yes.
Mr. Mensch, we received Dr. Ainsley's report in June. Is that right?
That's correct.
Of this year?
Yes.
And when did you reach out to Tao Fan to talk to her about your desire to have the kids do therapy with her?
Right in that time frame. Very
Okay.
close.
Okay. And did you also reach out to Dr. Bishop at the same time?
I did.
Okay. And can you just explain to the court why you wanted to use Dr. Fan and Michael Bishop for therapy?
Well, I object to the questions, particularly since they brought up qualifications. It's Miss Fan, not Dr. Fan.
I keep doing that. I'm sorry. I know that. Miss Fan and Dr. Bishop. Thank you, Mr. Gilbreth, for the clarification.
Because there's a lot of issues, these kids, there's a lot going on between us as parents. There's a lot of family issues. And I know that Dr. Ainsley understands these issues very well. This report did take a long time, and that gave her a lot of insight as to how our processes work and how our lives are and what issues the kids might have. And she recommended a team that I'm sure are very capable of supporting one another and supporting the children. And my concern with that not happening is that you get somebody that doesn't necessarily have those qualifications. They may be credentialed, but they're not qualified for the particular circumstances in our high conflict situation.
Okay. And have you spoken with excuse me, I'm doing it again, Miss Fan, about her availability to
Yes.
work with the family? And
yeah, each time
go ahead.
I've spoken with her several times, and each time she has had.
Well, I would object to everything after yes, because it's non-responsive and it's going to be followed up with hearsay. But the question was, have you asked? Yes.
Sustain.
Mr. Mensch, how many times have you reached out to Miss Fan about her availability?
4 or 5.
And over those time frames, what has your understanding been about her availability to take your case?
It's
Objection,
immediate.
hearsay.
I think I can ask about his understanding without it refer. I mean, I'm not asking him to provide a statement. I'm asking for his understanding of.
Yeah, I'm going to sustain hearsay.
Mr. Mensch, if Miss Fan is somehow unavailable, to not be as specific, would you also want to use another therapist recommended by Dr. Ainsley?
Yes.
Okay. For the same reasons as you would Miss Fan?
Correct.
Okay. All right. And when did you first reach out to Miss Welch about the possibility of using Miss Fan for therapy?
It was the last week of summer vacation.
Okay. And why wait until the end of summer?
We were traveling every week of summer.
Okay. So that was about and when about was that? You said the last week of summer. Was that in August?
Yes.
Okay.
I'm sorry, I didn't get the answer. Y'all are talking over each other a little bit. Thank you.
It was the big August.
Go ahead, Mr. Mensch.
The beginning of August.
Thank you. Mr. Mensch, I'm showing you what's been marked as respondents 2. Do you recognize this as a series of emails here between you and Ms. Mensch? I'm just kind of scrolling, or Miss Welch, excuse me.
Yes.
Okay. And we have combined these emails together, but other than that, and obviously these are forwarded to my office, but other than that, have these been changed or modified in any way?
No.
All right. I'd offer respondents 2.
No objection.
Okay. So
2 is admitted.
Here we see this email from you to Miss Welch on August 7th, where you're asking to, or you're attempting to connect Miss Fan with Miss Welch and everybody in the family, essentially, right?
Correct.
Okay. And what did Miss Welch initially said that she was setting her up at LifeWorks?
Initially, she said Miss Turner, the school counselor, might be able to have time. If you scroll down a little bit, it's in that.
Okay. Here on August 15th?
Correct.
Okay.
Then she came back with LifeWorks, which I objected to. Her son was there. That was absolutely not what the children need.
Okay. Can you explain a little bit more, elaborate a little bit more on the LifeWorks issue? What was the issue with LifeWorks?
Well, her son had been through enormous amounts of everything you can imagine. And the LifeWorks counselors would have the counseling with him like visible to his mother. The door was open. There was zero privacy. It was just, if there was any relevant issue, he would have been afraid to bring it up to the counselor. So that it made no sense to me whatsoever. It was just a disaster.
Okay. And at this point, Mr. Mensch, had you met with had you met Miss Marini or anything like that?
No, she had never been discussed.
Okay. Well, and Miss Welch had ultimately then suggested to you that Miss Marini come on board, right? She said that this was the person she was selecting for the kids therapy.
She did that, I believe, 2 sessions after, and I can't verify that. I know it was at least 1 session after the children had met with Miss Marini. The Savannah had told me that they met with a counselor the week before that, and then that week on Wednesday after the session, Katie sent an email saying that the children had met with this counselor, but she didn't tell me about the other time.
Okay. All right. And so were you able to get you were not able to get an agreement from Miss Welch to use Tau or Tau Fanner or another recommended? No. Okay.
No, not recommended.
And then are you aware of when I started trying to reach out to Miss Welch's attorneys on this?
It was in August, right? I believe.
Yeah. Me. So I'm showing you what's been marked as respondents for Mr. Mensch. And these are just kind of showing you, these are a series of emails between my office and Walters Gilbreth. Do you recognize these emails, sir?
I did not see the emails between you and their office.
Okay. Well, without admitting it, I'll just show you here that the first date that we reached out to Mr. Gilbreth's office was on September 5th about the issue.
If I could interrupt, it wouldn't it be appropriate to reference a document without it being admitted, but I don't have an objection to respondents for.
All right. Well, I appreciate that, Mr. Gilbreth.
So are you offering 4?
I am offering 4. 4
is admitted.
All right. And so September 5th, Mr. Mensch, was that the first time that it appears we reached out to Mr. Gilbert's office?
It appears officially that you were opposite, but we had been in contact. I'd been speaking with you about this since the beginning of August.
Right. Okay. And so just kind of scrolling through here, we can see that there have been multiple emails between my office and Mr. Gilbert's office, where we're trying to negotiate this, talking about splitting costs, and we follow up, it seems, with Mr. Gilbert's office about once a week on this issue. Is that fair? From what I've shown you so far?
Yes.
Okay. And then we aren't getting an agreement. So on September 26th, we try to set a hearing on the issue, right?
Correct.
Okay. And we go back and forth on setting a hearing for quite a while, until we're finally able to set something for the end of October. Is that right?
Yes.
Okay. Okay. And have you, so, and obviously we're not able to get that agreement, but have you met with Miss Marini?
I spoke with her on the phone.
Okay. How many times have you talked to her?
2 times. Well, 3 times.
Okay.
2 in one day. 2.
And part of Dr. Ainsley's recommendations, as you understand it, was that to provide any therapist with the substance of Dr. Ainsley's report?
Yes, it said specifically in the evaluation that any therapists and school people should be appraised of their report.
Okay. All right. And And did you talk with Miss Marini about the contents of Dr. Ainsley's report?
I did.
Okay. All right. So, and when you first spoke with her, how many times had she met with the kids?
I believe it was 4 or 5, somewhere to that effect.
Okay. Did you have any issues getting a hold of her initially?
I was given an address. I went by the address. There's no sign of anything there. I knocked on the door. I came back a few times. I looked on the internet. All the phone numbers associated with Miss Marini were not correct. So later I reached out to Miss Welch, and she provided me with the accurate telephone information.
Okay. All right. And did she give you any indication about what she was working on with the children at that point?
At that point, she said that the children thought there was something between the parents that they weren't knowledgeable of, and they didn't like that. And she said she was helping them work through that.
Okay. And did you talk to Miss Marini about any of your goals in the case, about what you wanted the kids to be working on in therapy?
I told her that I thought that there were a lot of underlying issues, and that they had a lot to deal with. And I just kind of appraised her of the report. I didn't specifically. I told her I thought one of the reasons for her presence is because there's likely to be some sort of big change coming, and that the children should possibly not be appraised of the situation by any means, but to be prepared that things change sometimes in life.
So y'all are in the middle of litigation. You're asking for a big change, but you weren't necessarily so you were communicating to her the possibility of a change, and that might be something that the kids would need to work through. Is that?
Yeah, correct.
All right. And what was your impression of Miss Marini when you met with her?
I was kind of taken back, as she'd only seen the children a few times, and she was very opinionated about what is going to be good for the children. She stated multiple times in our conversation that it's going to be terrible for the children if I take them from their mom. You just want to take them from their mom. I told her I told the evaluator explicitly, I do not want to take them from their mother. I had a childhood where my mother was absent for a lot of it. And when she came back, she wasn't an ideal mother. And I understand that limited time sometimes is much better, but that limited time is important because you don't want to take away from, I don't feel that one would want to take the mother away from the child, or children in this case.
So was it her expressed view to you that you were trying to take the children away from their mothers?
She said that multiple times, that you're trying to take them away from their mother.
And did she seem to have a pretty strong opinion about the relief that you were requesting, at least on paper?
Yeah, she told me it was a terrible idea, that it was going to hurt the children.
Okay. All right. And did she give you any of her thoughts on Dr. Ainsley or Dr. Ainsley's report?
Yes. She did not like the report at all. She said that it was all wrong. A lot of things were wrong. She didn't say all wrong. But she said that it's wrong. You guys just need family therapy. You need to work it out. And that she said that multiple times to me. We just need family therapy, which I wish that was the case. I mean, we do need family therapy, and we're in it. That's a portion of the puzzle, but it's not going to cure this. I mean, this has been ongoing forever, and it's not going to be fixed by family therapy. I mean, that's why we're litigating this. That's why we've done this whole thing. And she just seemed very dismissive that there was any reason to be doing anything as far as possession or anything else.
Okay. And did she appear willing to engage in the litigation process and custody litigation process?
She told me one of the first things she told me, I said, "Are you aware that there's a custody case here, that there's custody evaluation?" She said, "Well, the mother said she was afraid she was going to lose her kids, but I had no basis for that. I don't get involved in court cases." And that evolved over the course of the 45 minutes or so conversation to, well, if I was pressured, I would write a letter saying that it's going to be bad for the children, to her going off into a different area of her mind and rambling about mileage and court costs and all these costs associated with her involvement. When I didn't mention at all, I said, well, nobody's asking you to be in court. At that point, no one was asking anything of her. But she just kind of went off on I don't know what you would call it, a ramble about court being expensive and costs and mileage and this and that and all these things as applicable to her if she's going to be involved in court. So she went from, I don't go to court, I'll write a letter saying that it's going to be bad for the kids if you take them, to, well, all the stuff about cost, mileage, blah, blah, blah.
Okay. And Mr. Minch, have you spoken to the girls about Dr. Ainsley's report?
No.
Okay. Have you mentioned anything to them about what you want to be, like what your goals are for the litigation?
No, the children from me have heard absolutely nothing about court litigation. The only time the word court was ever mentioned to me is Savannah asked me about court. I said, "Oh, sweetheart, you don't have to worry about things like that." And I immediately changed the subject. And that was close to, I don't know, 6 months or a year ago. She just asked me out of the blue, and I quickly went to something else because I've never spoken in front of them about court. I've never alluded that there was any indication of anything that would be altering, their capacity to be with their mother or father or anything, or how things work.
Okay. And after that, you said that you've spoken with Miss Marini 3 times. When's the most recent time that you've spoken with her?
Last week, I believe.
Okay.
And
what did you guys talk about in that meeting?
Well, it started off very standoffish. I said, "Hey, I just want to check and see how the children are doing. If anything new came up." And she's like, "They're good." I said, "Well, was there, I know last time, you told me that they thought we were keeping something from them. And like parents weren't telling them everything about something, and you were helping them kind of deal with that." And she said, "Well, they know you're trying to take them from their mother." I didn't tell them. She says, so it didn't come from the therapist, and it didn't come from me. And she said, then she followed up with, the day after we talked, I get a thing from the court saying, or I get told that you're trying to get me kicked out of as being the child's therapist. I've never had anything like this happen. I said, "Well, that's surely coincidental that you got that information the day after. We've been trying to get this done since the beginning of August. There were recommended therapists that I wanted us to use because I'm sure Dr. Ainsley is competent in giving us providers that will be beneficial."
Had she mentioned anything about the children being anxious about you wanting to take them away from their mother?
Yes, she said that Savannah was very upset that I was wanting to take them from her.
Did you ask about what Miss Marini was doing to address that?
Yes, she said she just let it pass as quickly as possible, because if she would bring it up, then that would be all that therapy would be about.
Okay. Did you follow up or anything to get a sense of what Miss Marini might be doing to help with the kids' anxiety about that?
It didn't seem like there was anything. I mean, I said, just let it go. She's like, yeah, I mean, that would be all therapy would be about. We just moved on.
So Miss Marini has indicated to you that she did not tell the children about anything related to the litigation, right?
Yes, she told me that multiple times.
Okay. All right. And so, what other concerns do you have about Miss Marini working with the girls right now?
I think there's a lot of issues. I mean, that report outlines a lot of things, and I think they need to work through a lot of things. And I don't feel that Miss Marini's experience is really in dealing with and parsing out things like that. It sounded more to me like she's just there to listen, and that's her role, more or less.
Okay. And is there, what about Mr. Mensch? Is there just a concern about your concern about her perception of Dr. Ainsley and Dr. Ainsley's report?
Yeah, I mean, she said that she's not going along with their agenda multiple times. It's their agenda or her agenda. She's dismissive that the report's valid, and she says that there's an agenda put together by Dr. Ainsley, and she's just a neutral party that's not a part of that agenda. And to me, that doesn't seem like it's going to be beneficial to the helping of the children. She also said that I think you had asked her if she would work with Dr. Bishop, and her response was, "What's the goal?" It wasn't, of course. It was, I don't feel like the children are going to get the care that they need.
Is the issue more about her? Is it about her objectivity, Mr. Mensch?
Objection leading. The last introduction to the subject is also leading. So it's leading.
Sustained on leading.
What are your concerns, Mr. Mensch, about Miss Marini being able to kind of provide, be a neutral person as she has indicated to you?
Well, she's told me that I'm completely wrong and I'm going to damage the kids, and that everything about me wanting to get primary possession is going to harm the kids. So I feel she's a very biased party. She's already made up her mind that I'm going to hurt the kids somehow. She doesn't, and she did that immediately with only 4 or 5 weeks experience with the children.
And Mr. Mensch, more than Illinois or any other issue that you may present at trial, what's the most important thing to you for regarding your children?
That they end up without getting messed up. I want their brains, I want a stable environment that's going to lead them to a good life and give them the opportunities that they can have.
Okay. And if they have that here, if we get these kiddos into the kind of the team or the system that Dr. Ainsley was recommending, is that something that you're going to want to remove them from?
No, there's Zoom available if we were to be moving, but I wouldn't, even if we were to go out of state, that would not be a fast transition. I understand my children have relationships in school, they've got relationships with other people. The possibility, like if we were to move, that would be over the course of a year or something. It wouldn't be a fast transition, and the therapists are available virtually, both of them. They would stay with Dr. Bishop and Miss Mann.
And are you at this point even 100% committed to that move to Illinois?
No.
Okay, it's something that you've explored.
Correct.
I'll pass a witness.
Well,
Mr.
sir,
Gilbreth,
we're
go
set
ahead.
for final trial in 2 months, sir. Are you or are you not asking for the right to designate the primary residence of the children without regard to geographic restriction?
That was never presented. Illinois was an additional geographic region that was placed.
Okay, well, let me show you a live plea, and then I'll follow up and ask you specifically about Illinois. You recognize this as your counter petition, the suit affecting the parent-child relationship. Do you see that?
And that's 2020, correct?
Well, I'll represent to you that you're live pleading. But this case has been pending since 2020, correct?
Yes.
And y'all are set for final trial in 2 months, correct?
Correct.
And according to your live pleading, it is true that you are asking for the appointed sole managing conservator of the children, correct?
That was what we asked for at temporary hearings, correct?
Well, you asked for that on final and on temporary, correct?
I don't understand the question. There is no final. And it's my understanding that Illinois was an additional geographic restriction that would be added, or an additional geographic region. We haven't had mediation yet, and I'm hopeful that we can reach an agreement in mediation, but I don't know as it's likely, but there's a lot to think about.
Okay, sir. Well, let's just answer the questions that I have right now. Then I'll ask you specifically about Illinois. Your live pleading asks for sole managing conservatorship without geographic limitation put on counter petitioners. That's yours, right to determine the primary residence of the children. That's what you pled for, correct?
Correct.
And I guess I'm understanding to hear you that in 2 months you're not asking for sole managing conservatorship. Is that correct?
I'm still asking for sole managing conservatorship.
Okay, and you're still asking the right to determine the primary residence of the children without regard of geographic restriction in 2 months. Is that correct?
I don't know.
Well, sir, you've been pending for 4 years. How on earth do you not know? I'll withdraw. That's just argumentative. Are you asking for the right to move to Illinois in 2 months with the kids?
Potentially.
So I guess, so I understand the answer to me. You don't know, as you sit here 4 years into your litigation, whether or not you're going to be asking for the right to determine the primary residence in Illinois. Is that correct?
We haven't mediated yet. I've made no final decisions on what I'm asking for.
Okay. But you might be asking for it. Is that correct?
Correct.
Just like you might be asking to determine the to determine their primary residence without regard to any geographic restriction, correct?
That was never, I don't know if that was presented.
Now, under the underlying, well, I guess before I get to y'all's underlying order, did I understand you correctly that you believe that Miss Marini is not beneficial to your children? And one of the reasons you listed for her not being beneficial is because she told you she wants to be a neutral party and not participate in litigation? Is that correct?
After telling me that she was a biased party and I'm going to screw up my children, she said, I have disbelief in her neutrality.
Objection, non-responsive. Let me try just asking a follow-up question of the same question. I'm going to ask you in a bit about you believing that she's not neutral because she doesn't see the world your way. Right now, I'm asking you, if I understood you correctly from your prior testimony, that one of the reasons you don't think Miss Marini would be beneficial as a therapist is because she told you she was going to be a neutral party. Is that correct?
I mean, she wasn't going to participate in you have to give me a moment to think of the word she used. she alluded that Dr. Ainsley had a manipulatory system for the children, and that was.
Sir, what Ms. Marini has been consistent with you is that she would like to not be involved in litigation, correct?
Correct.
And the reason she's here today is because, well, let me put it this way. Only one parent has asked for the court to remove Ms. Marini as the therapist, correct?
Correct.
Only one parent has a motion before the court today, correct?
Correct.
That parent for both those issues is you, correct?
Correct.
Okay. And under the underlying order, oh, I guess let me ask you about you saying she's not neutral. Your position is that Miss Marini is not neutral because she doesn't see the world your way. Is that correct?
No, because she passed judgments within a very short time period that were impossible for a qualified person to pass in that time period without full information.
How many sessions has she had with your kids as you sit here right now?
I don't know at this point, but at the point when she was making those statements, it was like 4 or 5. It was very limited. And
well,
she admitted,
that was back in September. As you sit here right now, do you have any idea how many times your kids have gone to see Miss Marini?
I would think maybe 15-ish.
I'm not asking you to guess, sir. I'm asking if you know.
I don't know. I'm not
Have you
informed.
asked her?
I'm not informed when they go there. I know it's on Wednesday. When they go, they don't go every week. So I don't know.
So my question is, have you asked Miss Marini?
No, I don't think specifically that number is relevant.
Have you? Okay. Have you sat down and had a one-on-one meeting with Miss Marini?
I not in person, but on the phone, yes.
Okay.
Multiple.
So no, you haven't sat down with Miss Marini and had a meeting with her, correct?
Not in person.
And you haven't asked for one either, correct?
No, I'm not sure what.
You would agree with me that you and Miss Welch are a high conflict case. Is that fair to say? I think your lawyer said that in an opening statement.
Absolutely.
Y'all have difficulty reaching joint agreements. Is that fair to say?
Yes.
Y'all see the world differently, correct?
Yes.
She's in support of this therapist. You are not in support of Miss Marini, the therapist, correct?
Correct.
You would anticipate moving forward if you're allowed to pick the therapist, then she may disagree with that therapist. That's something that would not be out of the ordinary for y'all's family, correct?
I'm asking that the evaluator's recommendations be followed, not mine.
Sir, you're in here asking for the court to remove the therapist and to appoint Ms. Fan at your request. Given how conflict has gone in y'all's family, you would not be surprised if, say, Ms. Welch didn't agree with the therapist posited by dad's side. That would not surprise you, correct?
No.
Okay. Well, is that correct?
That is correct. I would not.
Okay. Under the underlying order, first of all, the first order y'all had from 2016 was an agreed order, correct?
Yes.
That y'all reached in mediation, correct?
Correct.
And under that order, establishing the parent-child relationship, showing you on my screen, it's filed in February of 2016. We just had Savannah at that time. Under that order, you agreed that Ms. Welch would have the exclusive right to designate the primary residence of the children or the child at that time within Travis and contiguous counties, correct?
Yes.
You agreed that she'd have the exclusive right to consent to psychiatric and psychological treatment, correct?
At that time.
Okay. And then the next order that y'all have, when you have your second child, is from March of 2019. Was that order agreed?
Yes.
Okay, so at that time, you agreed that Ms. Welch would have the exclusive right to determine the primary residence of the children now in Travis and contiguous county, correct?
Yes, I have no choices at these times.
And you agreed that she'd have the exclusive right to consent to psychiatric and psychological treatment of the kids, correct?
At that time, there was zero chance of me getting anything better than what we agreed on.
Is that a yes, Mr. Gilbert? I agree to that.
Yes, I agree to that.
And then in 2020, again, back to what you filed, you asked not only that you be sole managing conservator of the kids, but you see on your request for temporary orders, you asked that you be temporary sole managing conservator, correct?
Yes. I believe
Which would include. Go ahead.
I believe that we agreed on just splitting time because it was, at that time, we thought it was going to be a very quick evaluation, to your point, and we didn't think all these things were necessarily all that relevant in the time period. If we could get through the evaluation quickly, that this wasn't that something we needed to stand on fight about it in court. If we could get an agreement on having the evaluation so that someone could look into our situation.
Well, time out, sir. Y'all had a contested hearing, correct?
The temporary hearing?
Yes.
Yes.
A judge made a decision, and the request that you had at the temporary orders was that you be temporary sole managing conservator.
The judge didn't make the decision. The judge told us
I get, and that my client's periods of possession be supervised, correct? And you said that the present circumstances of the children significantly impair their physical health and emotional development. That's all what you said at temporary orders back in 2020 when Mr. Culp was your lawyer, correct?
Yes, but
okay.
The judge did not make that decision. He encouraged us to work it out amongst ourselves during break, and at that point, your client agreed that we would just split time and do the evaluation. We were under the impression that it was a 6-week or something evaluation, some very different time frame evaluation, and none of those factors were significant factors in that time frame. It turned out to be a much larger time frame where they became very relevant.
Well, sir, so first of all, you went from asking for that my client be supervised to saying that you should have a 50-50 possession schedule with the kids, correct?
Temporarily.
Okay. You filed something with the court back in 2020 saying that the children's...
I'm going to object to the relevance of this. I don't understand what going all the way back and rehashing these orders has to do with the relief requested today.
I guess let me re-ask a question and get to the point if I could. Sir, at the time when you reached the agreement that said, I was asking for supervised, I was saying the kids' present circumstances significantly impaired their emotional health and physical health and emotional development. At the time that I agreed to do a 50-50 with Ms. Welch, what you didn't agree to and what y'all didn't do was change Ms. Welch's exclusive right to make psychological and psychiatric decisions for the kids. Correct?
It was not thought through very well on my part. Correct.
Is that correct? Okay. By the way, Dr. Ainsley, your understanding hasn't talked to your kids in over a year, correct?
Correct.
I mean, is your understanding that she hasn't talked to your kids since June of 2023?
I don't know the exact date.
Does that sound about right?
Possibly.
What you told Ms. Marini is you did specifically tell her that the kids need to be prepared and this needs to be discussed the potential that they might be moving to Illinois, correct?
No. I said that there's likely a significant change and that I think one of the purposes of having the individual therapy is to make them maybe a little more open to things changing in the future, not specifically to that. I never alluded that they should be appraised of anything to do with us in our potential housing situations, time situations, any situations like that. I just feel...
Your opinion is that they should be prepared that they might move to Illinois?
No. I felt that they should just... The idea of change, generally speaking, should be explored, maybe probed, just to see how they feel about rigidity and change, and that it would be beneficial to them to kind of plant seeds that, things change sometimes in life. That's okay, right? You know?
Yeah, like we might be moving to Illinois, correct?
No, not that. Like,
Okay.
change sometimes.
By the way, well, you've asked, one of the things that Dr. Ainsley recommended was that we start family therapy, correct?
Yes.
And my client agreed to that, correct?
After we went to hearing,
Is it correct that we've agreed to start therapy? Dr. Ainsley said Dr. Bishop, but actually with an individual that's with Dr. Bishop's group. Is that
Yeah.
right?
that's Eliza Jorgensen, one of Dr. Bishop's associates.
And so we've been doing that for a couple of months now, correct?
Sounds accurate.
Well, how many sessions, how many family therapy sessions have there been?
I don't know how many mom's been to. I don't know when they go with mom. I think we've been there 4 times. They've been with mom probably equally, so I would say a couple of months.
And your understanding from your conversations with Miss Marini is that she's willing to work with a family therapist, correct?
Well, not exactly. Miss Marini, when she said that my attorney had asked if she was willing to work with the family therapist, and she said, "What's the goal?" She didn't indicate that she wanted to work with them. That's a kind of standoffish statement, in my opinion.
Your opinion is asking what the goal of family therapy from the individual therapist. Your opinion is these individual therapists for your kids asking you what the goal of family therapy is standoffish. Is that correct?
Asking what the goal of her working with family therapists, not
Okay.
family therapy.
You think that's standoffish, and one of the reasons why you think Miss Marini shouldn't be your kid's therapist, correct?
I think that
Is that correct?
Yes.
And I think I made this point, but I want to make sure I did. Miss Marini's consistent theme to you is that she wants to be what she has told you. I understand that Mr. Munch doesn't think she is, but she has told you that she wants to be a neutral party, correct?
Correct. And if I may, she said that she
Well,
would.
I'm looking at my notes. If you could wait till I ask a question if I have one.
Sure.
I'll pass the witness.
Mr. Mensch, is it your understanding that one of the things that Dr. Ainsley was recommending for a therapist for the children was someone who was willing to engage with the court system, like Tao Fan or someone else? And so when you're talking about neutrality, let me ask it a different way. So what you're concerned about is Miss Marini's, at least as your understanding of it, hesitancy to engage in litigation in the way that Dr. Ainsley would recommend someone like Tao Fan would be willing to participate, right?
Right.
Objection leading.
What?
Yeah, it's leading. So rephrase, I think. I'm going to sustain that objection.
What's your understanding of like, what is it about the willingness of a therapist to participate in litigation that is significant to you, Mr. Mensch?
I think that there's a lot of things that may or may not come out of the therapy. I think that the therapist's willingness to participate in the court process can bring light to the situation and how it is.
And how does that relate to Dr. Ainsley's recommendation about who the therapist ought to be?
Well, Dr. Ainsley's recommendation.
I guess I'd object because I think that's referencing a recommendation from Dr. Ainsley, which would be hearsay. I just don't want to be waiving that objection later on when Dr. Ainsley testifies.
Overruled. I'm overruled.
So it's my understanding that Dr. Ainsley has a team of people that will work together to benefit the children maximally. If there's a condition, something that's brought about in family therapy, it would be transferred to individual therapy. If there's something in individual therapy, it would go to family therapy to benefit resolution for whatever that issue is with the children.
Okay. Mr. Gilbreth had talked about a disagreement about therapists. You know, you and Ms. Welch not being able to potentially agree on a therapist or disagreeing on which therapist to go with. With that in mind, why were you looking to Tao Fan? Why would you suggest Tao Fan?
Because she was recommended by the Dr. Ainsley, who's spent an enormous amount of time looking into our situation and understanding it and understanding the needs of the children.
So kind of a tiebreaker in a way, right?
Yeah, it's not about I'm not going shopping for a therapist. I didn't go around asking any therapist what their views on this or that or anything were. I wanted to follow the recommendation of the person with the most knowledge and most ability to direct us into a productive path.
And you and Miss Welch agreed to the custody evaluation. Is that
Correct.
right? Okay. Okay. I want to go back to these orders that Mr. Gilbreth was referencing. Were those orders, did you and Miss Welch, the ones in 2016 and 2019, were those done at the Office of the Attorney General?
Yes.
Okay.
Yeah.
Did either? Go ahead.
The first one was a mediated settlement agreement, just because I couldn't take my kids anywhere. I couldn't take Savannah anywhere, and she was like, I had zero anything. So I had no money, no nothing. We had to agree on something. I took what I could get, which was that.
And did either of you have counsel present?
No.
Okay. And was it, you said there was a mediated settlement agreement. Was it one of those situations where there was just an attorney from the OAG just kind of hanging around with you, kind of going back and forth between the two of you guys?
On the second one. The first one, there was a lady that I don't even know where she was located, somewhere in Texas, that worked with mediation, and the mother and myself talked to her, and she's like, well, he's going to get this, he's going to get that. So the bare minimum that I was going to get is what got put in there. And I agreed to it because I had no means of fighting anything.
All right. And Dr. Bishop was agreed upon, correct?
Correct.
Okay. Do you know how long we were trying to reach that agreement?
Seemed like a very long time.
Okay. And we only reached that agreement like at a hearing, right? We were at court. We were in the courthouse when we made that agreement.
We were in the courthouse at a hearing.
Okay. And you agreed to pay for all of that, correct?
Correct. I had agreed to pay for all of it before that hearing. It wasn't like it was like a new thing.
Okay. And you're also agreeing to pay for Tao Fan, correct?
Correct.
I'll pass witness.
Well, sir, just briefly, your proposed disposition of issues in your live pleading has always said the cost be split 50-50, correct?
We asked initially, like a long time ago, in August time or September, the beginning of September, we asked for costs to be split 50-50. But then we agreed at that hearing, that very first time we went to a hearing, we agreed to pay solely for Tao Fan, if not before then.
Well, I'm talking about Dr. Bishop. Your complaint is that there wasn't an agreement on Dr. Bishop until we got to the courthouse in October. Your live pleading then, and actually your live pleading now, says that the cost be split, correct? Actually, maybe in your proposed disposition.
I'm gonna object. I stipulated in the record at the beginning of the hearing that Mr. Mensch would pay the cost of Tao Fan.
Right, but their complaint was that we hadn't agreed before then. It wasn't until the hearing that we had an agreement that he pay 100% of Dr. Bishop. So I think that's the point. So I think with the stipulation,
sure.
the
And I'm
point's
going
been
to
made.
overrule the objection, but let's not spend too much time on this because it seems sort of moot at this point. But you can ask this one question.
I think I made the point. In 2016, sir, when y'all mediated, and made agreements about conservatorship, including Miss Welch having the right to determine the primary residence and make psychological and psychiatric decisions. The attorney from the Office of the Attorney General was involved in that mediation, correct? Including when y'all were making decisions about conservatorship, correct?
We just took a mediated settlement agreement in and had it signed that was drafted by the mediator from wherever in Texas.
Okay, and that was signed by you, Miss Welch, and the Attorney General, correct?
Correct.
And then in 2019, there was like Mr. Culp was referencing, there was a negotiation with the Office of the Attorney General there about conservatorship, possession, access, and support, in which y'all agree that mom would have the exclusive right to make psychological and psychiatric decisions, correct?
Yeah, there was.
And in December 2020, you talked about you didn't have the means in 2016 and 2019. In 2020, you certainly had the means to argue for and ask for the right to make psychological and psychiatric decisions, correct?
Well, more so, but
Well, you're
not. I mean, I came here on a thread.
Is that objection non-responsive to everything after
Sustained
more
on
so?
non-responsive. You may ask a question.
You were represented by Mr. Culp, the lawyer that you have right now, back in December of 2020, when y'all made no changes about my client's exclusive right to make the psychological and psychiatric decisions, correct?
That's correct, but as I had stated previously.
Objection non-responsive to everything after that's correct.
Sustained.
I'll pass the witness.
Nothing further, Your Honor.
All right, thank you, Mr. Mensch. Mensch, I can't, is it Mensch?
Mensch.
All right, thank you. Then you can step down as a witness and we'll move on to the next witness. But actually, let's take a 10-minute break, Mr. Culp. And I have to be done by noon, absolutely. So because I have a meeting at noon that I have to be at. So that's the time frame. So I don't know how much you're calling anybody else, but that took a significant amount of time. And so how much more direct do you have? Are you calling Dr. Ainsley or are you done?
I'm going to call Dr. Ainsley and Miss Marini.
Well, then you're going to have about 15 minutes at most with each of them.
Okay.
All right. And I mean, Mr. Gilbreth still gets some time and we're done at 11:55. Absolutely hard stop. So we'll take a 15-minute, we'll start it around 11. I hope that's going to give Mr. Gilbreth time. I think it is, because I don't know that you have any real witnesses, correct, Mr. Gilbreth, other than responsive witnesses?
Right. I would call Miss Marini, and I will. So you have in the back of your head, I will be objecting to Dr. Ainsley testifying. I don't have her file, right? Not,
right.
Put aside the
Actually,
fact that,
you know what? That makes it easy. Are we still on the record, Ms. Roccanelli?
Yes, Judge, we are.
I don't think I'm going to allow Dr. Ainsley to testify. He doesn't have the file, and I think that's inappropriate, Mr. Culp.
Well, he has her report, and I was just given an agreed order to release her file today by Mr. Gilbreth's office. If there was another one that was sent prior to today that I missed, I'm happy to have that called to my attention. But
she's been so long. Is she a court appointed? She's court appointed, right?
Yes.
right.
And court appointed. What, like a court appointed guardian ad litem?
Custody evaluation.
Custody evaluation. And I mean, it's not in every case that we request the custody evaluator's file. It's something that they're entitled to. It's also something they're entitled to set a hearing on, which they haven't done. We've not objected to it.
Well, you don't have a lot of time. So take a 5-minute break, come back. But I promise you, if Dr. Ainsley, I'll go back on what I previously said. She's going to get about 5 minutes, Mr. Culp, because you're out of time. You spent a long time with Mr. Mensch. We spent a long time with him, and it is 10:45. And I promise you, I have to allow Mr. Gilbreth to call Miss Marini, who you're attempting to remove as the therapist. And so you're going to get to the point with Dr. Ainsley and get to the point quick. And we'll just get to it very quickly. I'll allow it. I'll overrule Mr. Gilbert's objection, but it's going to have to be very targeted and very efficient. Thank you. I'll see you in 10 minutes.
Thank you, Judge.
All right, we are back. Ms. Roccanelli, we will go back on the record, and Mr. Culp, you may call your next witness.
Okay. I'll call Teresa Marini.
Okay, Ms. Marini, please raise your right hand. Be sworn in. Oh, unmute yourself. Oh, still not unmuted, but let me push and maybe you will know how to unmute yourself. Hold on. There we go. There, that looks good. Raise your right hand and be sworn in. In the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. Proceed, Mr. Culp, and realize you've got limited time.
Well, and I was going to ask a clarifying question. I'm sorry, Your Honor. Are you saying I have 5 minutes left?
No, I'm saying you got about 10 minutes with each witness, but I promise you, Mr. Gilbert has got to have time. I don't know the answer to this question because you used up so much time with Mr. Munch that it's hard to know. I mean, I would keep it maybe 5 minutes to each witness because he went for so long. And you only set this for 2 hours. Then you asked for 2.5. You're getting 2.5. But you went with him for an hour and 15, hour and 20 minutes. And so that's just, it is what it is.
Okay. I just was making sure.
Yeah, you're really out of time, but I just don't think Mr. Gilbert has much other than his response. And so, you know, we'll see, but I would be very thoughtful about time.
I will do that, Your Honor. Thank you. Ms. Marini, would you please state your full name for the record?
Teresa Ann Marini, LCSW.
And Ms. Marini, how many times have you testified in any kind of contested custody matter?
Probably at least 20 or so over the years.
Are these in high conflict custody cases or just in CPS cases?
Mostly CPS cases.
Okay. Have you ever worked with Dr. Michael Bishop?
No.
Have you ever worked with Dr. Jim LaFan?
No.
Have you ever worked with Tao Fan?
No.
Have you ever met Dr. Ainsley or met Dr. Ainsley before?
No.
Have you ever been part of a therapeutic team involving family therapy and children's therapy? Or
Yes.
family therapists and children's therapists?
Yes.
How many times?
It's hard to find those kind of teams, but at least a handful of times.
Outside of the CPS context?
Mm-hmm.
Okay. You've read Dr. Ainsley's report, correct?
Correct.
Okay. And you and I spoke on November 19th, approximately. Do you recall that?
Possibly, yes.
Okay. And during our phone call, you relayed to me that you believe that Dr. Ainsley's report was biased, correct?
Yes.
Okay. You told me that you didn't think that Dr. Ainsley's report made any sense, correct?
Correct.
You said that you thought that Bill was trying to take the girls away from their mother, correct?
Correct.
Okay. And you told me that what you thought Bill was but Mr. Mensch was asking for in this case was not good for the children, correct?
Correct.
And that was after I think you'd seen them at that point about 6 times?
Probably 6 to 8 times by then.
Okay. And you told me that in that report, you didn't have any concerns about Ms. Welch at all, correct?
Not at this time, no. I have observation of Miss Welch, and I have no concerns.
Okay, but you did have concerns about Dad based on Dr. Ainsley's report, correct?
That is correct.
Okay. You had also said that that you thought that it was crazy to take the kids away from Mom, correct?
I don't know if that was my clinical speak, but I would agree to that.
Okay. And you also told me that you didn't want to be a player in this case, correct?
A player? What do you mean?
You didn't want to be involved in the litigation component of this case, correct?
I said that I like to avoid being involved, but if it was necessary, I could be fully involved.
Okay. And you did tell Mr. Mensch that if you were asked to testify that you would write a letter to the court explaining that you thought what he was asking for was wrong or bad for the kid.
Mr.
Right?
Mensch kind of confused that issue.
Okay.
I never said that I would not participate in any sort of way.
Okay. You understand that Mr. Mensch is not asking for Miss Welch to not have any time with the children at all, right?
I understand.
Okay.
2 weekends a month.
Past witness.
And how often have you seen the, yeah, I'm sorry, ma'am. Miss Marini, how often have you seen the children?
I would say I've seen him 12 times since the end of August.
Do you do sessions together with both kids or you do it separately?
The kids come at the same time, but they get their own time in the therapy room. I have a full office suite, so they have space where they can relax while the other one is talking.
And let's not go into too much of her private stuff, but how's Savannah generally doing the therapy?
She is really good. She wants her own time. So she comes in. I don't know if you can see the room, but I have a room where you can have as much privacy as you want, where you can shut the windows, shut doors. So she always wants time. She wants to discuss some of her own drama, but in recent sessions, she's discussed how upset she is about, not being able to spend that. She's afraid that she's going to be taken with her mom. She wants equal time with both parents.
And what about, is she aware that there's a possibility that she may be moving to Illinois or outside of this area?
She is aware. She didn't tell me how she knows. She just said, I have my ways.
I mean, she certainly talked to the custody evaluator who's investigating things like whether or not it'd be best for her to move. Is that your understanding?
Say that. I'm sorry.
Well, Savannah certainly talked to Dr. Ainsley about this case, the custody evaluator, including things about whether or not she's moving. Is that your understanding? And if you don't know, you don't know.
I'm not sure
Okay.
what you mean.
Well, how was your relationship with Savannah?
She is starting off very well in therapy.
With kids, sometimes it's fair to,
Good therapeutic bond with her.
and that's what I was going to ask. With kids, sometimes is it fair to say that sometimes it takes a while, particularly kids when they start hitting their preteen, well, I guess not quite preteen, but I'm sure Savannah thinks she's a preteen. But is it fair to say they take some time to warm up to a therapist sometimes?
Absolutely.
And how can that affect the success of therapy if we have to sort of start over from square one as far as developing a relationship with a therapist?
That is difficult for they start a relationship and they want to be able to have trust. And so to be able to open up and then have that trusted relationship taken away and being told just, oh, start that over with somebody else can be more complicated. And some people they might relate to and some people they might not.
Do you feel like Savannah relates to you?
Yes.
Are you at the point as with treatment with her, do you need to pry stuff out of her or is she pretty open with you?
Do I need a what?
Do you need to pry stuff out of her or is she pretty open with you?
I don't do prying.
Is she pretty open with you?
Yes.
Does she seem comfortable in session with you?
Yes.
And you may not have talked about it, but have you ever asked her about if she's comfortable with you continuing as her therapist or not?
No, I wouldn't ask her that question unless she brought it up.
And has she brought it up?
No, she hasn't.
Okay. Has she had any resistance from what you've observed, any resistance from going to treatment with you?
No.
And what about Cora? How's Cora doing?
She's doing great. She's 6. She's likes play therapy. She likes to do art and be creative.
Does she seem bonded with you as well?
Yes,
And as far as your relationship with Cora, how do you think the therapeutic relationship is?
it's very good.
Is it the same answers that you had for Savannah as far as the idea of sort of switching a therapist after a child's already developed a relationship with that therapist?
That's correct.
By the way, is it you understand that you're the first therapist these girls have ever seen?
Yes.
Talk to me about if it's easier to do it for each individual kid or if you want to do it together. Do you have a set agenda for each therapy session that you need to set? Like we need to talk about this, or is it child driven, or how do you manage that situation?
It is definitely child focused. What they feel comfortable, what they want to bring up, it's their time. I have a suite that is set up so they can relax somatically and emotionally, and I encourage them to open up and talk about their feelings, but that's as far as they go. I don't lead them or try to have any set agenda.
What are your thoughts about Dad's testimony earlier today that you need to be preparing the kids for potential major changes in your life? Do you view that as a role that you have?
No, I don't.
What?
If there was definite changes that were going to happen that were written, then I would help them with that. But there is not. So, especially since Savannah has already told me that she's really worried that something could happen like that, it wouldn't be appropriate with me not knowing what's going to actually happen. It wouldn't be an appropriate therapy conversation.
What interaction have you had with Mr. Munch?
I've had a couple phone calls. He says 3, there might have been 2 in one day, but 2 different days that I spoke with him.
And what's that interaction been like?
It's been interesting. I was trying to encourage him around that this could be very difficult emotionally for his kids, and that might even be bad for his relationship with his kids. With them, they love their mom very much. It's their mom. They do not want to be separated from her any more than they are. Savannah has told me when she's with her dad more than that week, she misses her mom and vice versa. And she's happy with the 50-50 custody. And I wouldn't want her not to be happy with the time with him. And so, but I don't really understand the goal. My understanding is in the state of Texas, there has to be some kind of severe abuse to take a child away from their parents or remove custody.
Yeah, hold on, Miss
Okay.
Marini. That's I can't hear Mr. Colt.
You're not muted. You're just talking, and we can hear you.
Objecting, non-responsive.
Okay, I couldn't hear that was an objection. It almost sounded like you were talking to somebody. Sorry.
No, I apologize.
I agree. I'll redirect her.
Okay.
Thank you. Go ahead.
Okay. No, ma'am, it's just we got to do question answer. Just
so can I bring something else up? Oh, go ahead.
Well, let me ask a question. Is there something that you would like to bring up?
Okay, I'll let it go.
Well, first of all, let me say 2 things. Let me say something and then follow up with a question. First of all, it's Miss Racanelli's really good, but she'll tell you I'm really bad at interrupting people, and I'm really bad at talking fast. If you could make sure I'm done asking my question, and I know it's hard over Zoom, but asking my question before you respond, that would be helpful. So my question was, is there something else you wanted to bring up?
Well, I have a couple concerns. My first concern is Mr. Munch was saying that I kept saying
as to narrative. It's what do you want to bring up?
Right. I think we can't allow that, Mr. Dilbreth. So
yes, ma'am.
I have to sustain the objection.
Okay. Do you have a couple concerns, ma'am? Well, just a yes or no. Do you have a couple of concerns?
Yes.
What's the first concern?
My first concern, of course, is the emotional well-being. When I asked Mr. Munch about their emotional well-being, he said, I'm not removing the kids from their mom. I'm restructuring their life. I'm concerned that he has a way to understand the emotional needs of the girls for their mother.
And what's the other concern?
My other concern is when I asked him, what is the goal of family therapy? He said the goal was for their mother to agree that the kids would be better off with him.
Now, family therapy, are you willing to work? Well, first of all, let me ask you this. Are you understanding that we've started family therapy?
I am not against working with a therapist on a reasonable goal. I don't understand the benefit of family therapy for this family at this time. When the parents have so much they need to work out, it doesn't seem fair to bring the kids into it.
Fair point. But if they're going to do family therapy, are you willing to work within that system?
If the goal is going to be productive in helping the kids.
Does conflict hurt your patients, your clients?
Absolutely, yes.
Okay. Does fighting over things like who our child's therapist is, does that hurt your patients?
Any conflict would probably upset my patients.
Have you expressed to Mr. Munch that you want to be a neutral in all of this?
I expressed to him that, how did I express it? That I'm trying to remain unbiased, but I don't believe that they should be taken from their mom.
And here's well, I guess first let me ask you, what is your licensures?
LCSW.
And how long have you been? For the record, can you tell us what LCSW is?
Licensed clinical social worker since 2000. I graduated in 2003, so it would be 2005 probably when I attained, let's see, actually 2010 when I got the LCSW. I had the smaller license before that.
And what's your educational background?
I went my undergraduate in painting at Ohio State University, and I got my master's in social work from Boston University in 2006.
And for your practice, what percentage is it that you're seeing kids versus seeing adults?
I would say I have all ages from toddlers to people in their 70s, but the bulk, I'd say 90% of my clients are kids and teenagers.
And by the way, when's the last time you talked to Dr. Ainsley?
We had one conversation that would be in November. It's just recently in November that I was kind of exposed to the whole case and what's going on and the report and Dr. Ainsley and everything else.
Was it your hope before then to not be exposed to all the conflict?
I didn't quite, I tried to screen out custody cases, not because I never said anything about mileage or any of that stuff. I'll just tell you that. But in general, it is a lot of work for me pro bono. That's part of being unbiased, is I'm not being paid by any of the players in this. I just bill the insurance. And so I'm just going to do my best.
By the way, do you think your patients benefit more from being in person with a therapist as opposed to doing it over Zoom?
With kids, it's really better to do it in person if possible.
Okay. And then last really important question is, having been exposed to the conflict in the court system, are you willing to continue to see these girls?
Yes.
Okay, I'll pass the witness.
Mr. Culp.
Yep. Nothing further.
All right, thank you. Ms. Marini, you are excused as a witness. You are free to go or to stay, since the hearing in many ways is involving you. But you're released from you're released from being a witness at this time. Thank you.
Thank you, Your Honor.
I'm going to mute you again. All right, where do we go next, Mr. Culp?
I'm going to call Dr. Daphne Ainsley.
All right, Dr. Ainsley, I know you're here. Please raise your right hand. And the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Culp, I'm going to give you about 10 minutes because you went so efficiently with Ms. Marini that if you want to take 10 minutes with Dr. Ainsley, you can take 10 minutes with Dr. Ainsley.
I appreciate that, Your Honor. Thank you. Dr. Ainsley, would you please state your name for the record?
Daphne Leah Dominguez Ainsley.
Okay. And very briefly, just kind of cut to the chase. Miss Dr. Ainsley, why did you make the specific recommendations that you did regarding therapy for the children in your custody evaluation?
I made the specific recommendations, and today we're talking about Miss Fan. I recommended Miss Fan because she has a long history and experience in working with high conflict families. She had space at the time when I recommended her. I'm understanding she currently has space. She has worked in therapeutic team formats, which I think would benefit this family. Also, she has, in what I've seen in my experience with her, is that she does a really good job of including both parents in her treatment at an equal level to the degree that's possible when working in high conflict families. I think that is very important here to have both parents heard, again, in an equal way as much as possible. Miss Fan has also attended continuing education with AFCC specific to court involved therapists, which I think is really important and critical when working with these families.
Why court involved? Why is that so important? Is it important for this particular family?
I believe it is important for this family. AFCC has produced some guidelines for therapists working in high conflict families, and they did a good job of outlining the involvement that is required and beneficial. Additionally, Ms. Fan's therapy, I think, is really structured, depending on the case that is. And I think it's helpful in these families that have been in conflict since the beginning of the relationship to have some structure and order in place.
Okay. And you've spoken with Miss Marini, correct?
I have spoken with her, yes.
Obviously, you've heard her testimony.
Yes.
Do you believe that she kind of has, I understand that she's got credentials, but do you believe that her experience, based on what she's told you or told the court, fits with what you're looking for in terms of a therapist for the children?
You know, I've spoken with Miss Marini one time. It was not known to me before. I was alerted that there was a therapist even in place. After I submitted this report, I don't think there was any communication from anyone regarding the treatment process. I did know that Dr. Bishop was contacted, but I didn't know about any individual therapy for the girls. So this was all new to me around the same time that I contacted Miss Marini as well. When in speaking with her, one of the questions I had was about her treatment plan. I don't understand her treatment plan for the girls. I understand that her office is able to close the door, for example. And my understanding is that the treatment is very fluid and that the girls could come and go in and out of her office, including mom. The door could be open, the door could be closed. Another concern is that there was not a communication with dad. Dad has not been to the treatment. I think we're all aware in working in these families that it's really important to try to be a balanced person and to collect data from both parents.
Did Ms. Marini say anything else to you during your conversation with her that caused you concern?
Oh gosh, I don't remember, Mr. Culp. I think one of the things that I communicated to you and to Ms. Glick, who works with Mr. Galbo's office, is that I would have liked to have known that this was in progress and that both parents were involved in meeting with Ms. Marini from the outset. So that would have been in August of this year versus I'm not sure when Mr. Minch was informed.
Okay. Do you have any thoughts on Ms. Marini's concerns about your report?
My understanding is that in order to come to some conclusions about possession and access, one has to conduct a custody evaluation. So I think that's one consideration for the court here to hear the statements related to possession and access. Also, I see a therapeutic process for these girls as helpful and beneficial. And also having an alliance with the treatment team and what the needs of the family are, because we're in a family system here. And although the girls are the client for her, I think being able and willing and open to working with them, that system is going to be beneficial. And considering what each parent brings to the girls, I think would be beneficial.
I guess specifically, what about, is it concerning to you that she considers your report and your recommendations to be crazy, biased, making no sense?
Well, objection leading and objection misstates her testimony.
I think it's got to be leading. So, sustained.
Well, you heard what Miss Marini said about your report, Dr. Ainsley, right?
Yes.
Okay. Does it concern you that she has those opinions of that report? And I don't mean for you personally. I just mean about the ability to do treatment in this particular case overall.
I think as the therapist, the focus should be, again, on helping the girls, having a treatment plan to do so, reviewing the report. My understanding is she just received and reviewed the report in November, which was months after starting the treatment with the girls, which I think is problematic. It sounds like she was not informed at the treatment inception that there was this litigation in this way ongoing, which I think is also a concern for me. People will disagree with me. Mr. Galbraith has brought up several points today about disagreeing with my conclusions. And so while I think that's part of the process that we're all involved in, I think having the ability to kind of keep those, everyone will be influenced by whatever we read, see, observe, etc., but to be available to the girls and keeping that as the focus would be exceedingly important here.
Okay, I'll pass witness.
Well, hold on, Dr. Ainsley. One of your points is we want the therapist to be neutral and kind of outside the court focus and the litigation and possession access and move and all that sort of stuff, correct?
No, I didn't say that,
What,
Mr.
well,
Galbraith.
is that correct? Is that correct?
I would not. Are you done with your question?
You wouldn't agree with me that the therapist should be neutral and not be specifically looking at issues for possession and access and move and conservatorship and those types of things. Would you not agree with that?
Not with the two parts to your question. I would not agree with both of those parts.
And one of your complaints is that she didn't have the report to November. Have you asked Dad, Mr. Munch, why he didn't send the report to the therapist?
I have not asked either party here about their sending the report to the therapist.
Have you asked Mr. Culp why he didn't send the report to the therapist if that's supposedly an issue?
I have not
asked
asked
Mr. Culp?
any. Are you done with your question, Mr. Galbraith?
I am.
Okay. I have not asked anyone about the report. I just learned this morning in Ms. Marini's testimony that she received the report in November.
Okay. And by the way, her saying that your understanding is that Dad's position, Mr. Munch's position, and what he's expressed to you is that he wants to relocate with the kids to Illinois, correct?
I understand that, yes.
And if he's successful with that in 2 months' time, then you understand that could mean that the kids could be relocating to Illinois, correct?
I understand that, yes.
Okay. And you believe that the kids' therapy should be in person, correct?
I would agree that most of the time therapy should be in person. I would recommend it for these girls, yes.
Okay. So I should have asked a more specific question. Specifically for these girls, both these girls, it is better for them to be in person with their therapist, correct?
I believe that, as I've noted in the report, with school as well. I think for these girls, in person is best.
And by the way, you haven't heard Miss Marini testify about what a specific recommendation for possession and access is. Rather, she's expressed to Dad that she thinks taking the girls away from Mom would be detrimental to her patients, correct?
I know that she has said that. I also know that she has said the girls would not benefit from less time with their mom.
Okay, that's a therapist's role. That's not making a specific recommendation to the court on conservatorship or possession access, but rather saying from her client's perspective, it would not be beneficial to them, correct?
I think you're asking a different, I'm not understanding your question to be that, Mr. Galbraith. What I think would be less biased would be to say the girls want 50-50 time with their parents. Her position, as I understand it, is that the girls should have 50-50 time with their parents.
Did you hear any of that in her testimony earlier today? Yes or no?
I believe that I did, yes.
Okay. Did you hear her saying it would be detrimental to the kids and they would be emotionally impacted from being removed from a parent? That is certainly within her scope, correct?
As their therapist, I believe that she can say that and she can have that opinion, yes.
By the way, when's the last time you talked to Savannah?
That would have been in August of 23.
Okay, so a year and I should be able to do the math. A year and 4 months ago is the last time you talked to the oldest child, correct?
That she was in my office, yes.
Okay, well, I didn't ask you the last time she was in your office. I'm asking the last time you've talked to Savannah. Is that the same answer, though? That's been a year and 4 months?
I don't know the answer to that, Mr. Gilbreth. I'd have to go back and review my calendar.
Well, in your notes, too, correct?
I do know that probably, yes.
Okay, your notes, which you've told me and Mr. Culp you won't release unless you have a court order to do that, correct?
I said a court order or agreement by the parties, which is in my policy that each of the parties completed at the inception of this process. Yes.
But in any event, whether it's August or whatever, it's 2023 is the last time you talked to Savannah, correct?
I believe that's correct. Yes.
And same answer for Cora, correct?
That would be correct. Yes. Again, I've just for the benefit of the record, I'd like to go back and review my record to be complete in that answer. But to my memory, the last time that they were in my office was in August of 23.
Okay, but just to be clear for the record, Dr. Ainsley, since we are not just in your office, but your recollection is having any contact with either one of the girls has been since 2023, correct?
Mr. Gilbert, like I said, I'm not able to answer that right now. I do not remember without reviewing that. I'm sorry that I don't have that information right now, but that may very well be the case, but I'm unable to answer with 100% certainty at this moment.
Were you aware? When did you first be made aware that you were ordered to conduct a custody evaluation in this case?
I believe it was early in 2021, early spring, maybe January of 21.
Okay, and of course you review court orders that appointing you whenever they're signed, correct?
Whenever they're submitted to me, that's whenever I would review it, yes.
Well, that's how you came to know that you'd been appointed to be the custody evaluator in this case, is because the order was submitted to you in early 2021, correct?
That's correct.
And you reviewed the language that said your report was due July 1st, 2021, correct?
That is part of the order, yes.
Okay, and your report was issued in June of 2024, correct?
That is correct.
I'll pass the witness.
Dr. Ainsley, there was a good length of time between the time that you were appointed and the time that the evaluation came through. Can you help the court understand why that might have been?
A number of reasons, and I will start with saying that that's it's an extremely long amount of time. I don't believe that it's ever taken me working with the family that long. I think the attorneys on this case are well aware that there were other cases that I've worked on with these cases and been in front of the court that have not taken this long in that time frame. There are a number of things that took place in this family. I think one of the things was, and again, I believe I started meeting with the family members, that is, in May of 21. So there was initial time period for them to get paid up and begin the process. Similar to the end, this report is dated April of 2022. I think I wasn't paid in full until June of 2020. Excuse me, April of 24. I believe I wasn't paid in full until June of 24, so I could release the report. There were a number of...
Who were you waiting on payment for?
Miss Welch. There were a number of releases that I had requested that took some time to get. There were CPS records that took some time to get. I will state for the record, as a personal aside, my father passed in this time. I notified both attorneys about this, and I had to manage some of that. Additionally, I think this family also, one of the things specific to this family was that Savannah, while along this process, was identified to have some additional educational learning problems. So she had to come to my office on several occasions to continue to be tested for those, which was completed by me, in addition to my communication and record review of the school psychologist who conducted the testing there. So that's how I can answer that.
Who are you waiting on for releases?
I don't recall at this time, Mr. Culp. I know that for one example, I was not able to speak with Ms. Welch's previous therapist. That was one person, for example, that I was not able to communicate with. I like to do that in every case, at the very least, and I was not able to do that in this matter.
Pause witness.
Ma'am, one thing that's important for both these girls is stability, correct?
Yes, I agree with you 100%.
And predictability, correct?
That's correct.
And you understand these folks have a final trial in 2 months, correct?
Yes.
You understand they're going to be fighting about where these girls live, correct?
I understand that.
And you understand they're going to be fighting about which parent gets to make the decisions for psychological and psychiatric decisions, correct?
Yes.
And you understand that currently, because for high conflict families, it's fair to say that saying y'all have to agree a lot of times is not successful. Rather, you have to have a decision maker, correct?
I would agree with that. I've made recommendations with that in mind. Yeah.
Okay. And for a high conflict family, it's not inconsistent. It's not unusual for one parent to feel like if the other parent picks a therapist, that therapist is biased against them. Fair to say?
I know that can be the beliefs of some parents. Yes.
Okay. Well, and by the way, one of the things that you said with Mr. Culp was that you want dad to be heard, both parents heard, and dad's not been to treatment. You heard his testimony that he hasn't even asked to meet with Miss Marini, correct?
I did hear that, yes.
And that's, well, I'll pass the witness.
Anything else, Mr. Culp?
Just real quick, Dr. Ainsley, obviously, whoever is the therapist for these children isn't just going to start and stop with the date of final trial, right?
I would certainly.
Well, I would object to her speculating to that. I'll withdraw the objection. Get through it.
Presumably, we're trying to find somebody who is going to be working with these children for a very long time, or as long as they need, right?
That is my recommendation, that they stick with a therapist who can treat them individually, each individually, not together, for an extended period of time. I see these girls as developmentally very young. I would like them to have a treatment provider that they can access throughout their adolescence and, on their way to college if needed. That's what I envision for these girls.
Okay. I can have just a moment. I'll pass the witness, Your Honor. I'm sorry. I was just looking for one thing. I didn't.
Anything, Mr. Gilbreth?
No, ma'am.
All right. Thank you, Dr. Ainsley. You are excused as a witness. You're free to go or stay. Thanks.
Thank you.
All right. Is there anybody else that you're calling Mr. Culp?
No, Your Honor.
Mr. Gilbreth, are you going to call anyone?
No, ma'am. I believe I've made my point.
Okay. Having heard the evidence, here's where the court is. I'm not going to grant this motion, but here's what I'm not doing. I'm going to say all this. I am not making a decision on a permanent basis about the therapist for the children. I'm just saying that the trial court can hear this matter and make a decision at the time of trial. I'm not doing anything today. The kids are going to continue to see Ms. Marini. This matter can be considered again by the trial court judge and rolled in to the final trial. I think it'll be appropriate to have some of these issues come up in the final trial. I'm not cutting them off, and you're not going to be able to revisit them again. I'm also not making a ruling about the scope of the things that Ms. Marini can testify about, because some things will not be allowed by the trial court judge with regard to thoughts and opinions that she might have about possession and access or conservatorship. I think there are lines to that I don't want this opinion of allowing Ms. Marini to continue to treat the children in therapy for the next 2.5 months to be used in any way at final trial other than what it is, which is the kids are in therapy with Ms. Marini. They're going to continue in therapy with Ms. Marini. And the issue of therapy for the children is a perfectly appropriate issue to be rolled into a final trial and should, in fact, be rolled into a final trial. So, anything else you need from me?
No, ma'am.
All right. Thank you. You are all excused. Good
you.
luck.
Thank you, ma'am.
And we can go off YouTube, Miss Jones.